Hi, everyone. Thank you so much for joining us for our webinar today. My name is Dustin Salariaga. I'm a senior associate at Scott Legal PC. And today we're going to be spending some time talking about a very common question that our firm gets from our clients, which is how to move from a non-immigrant visa to a green card. We'll be focusing on a few categories of green cards, specifically in the employment-based green card categories. So these include the EB2, the EB1, and the EB5. And we'll also be talking about options for entrepreneurs. We are very fortunate today to have the founder of our firm, Ian Scott, here to speak with us and share his expertise. He has a significant experience helping clients navigate this process from non-immigrant visas to green cards. And he's personally navigated a number of non-immigrant visa options as well. In fact, our firm was founded on an E2 visa over a decade ago. A few things before we get started. Even though our firm does focus on business immigration, we handle the full spectrum of immigration law. That includes family immigration, humanitarian immigration. So we really do hope that you don't hesitate to reach out to us if we can be of any help at all in any of these categories. We try to do at least 2 webinars a month, and I think at this point we're probably doing about 2 a week. And so these do cover a variety of aspects of U.S. immigration, like I mentioned before, family, humanitarian, business immigration, of course. So we do hope to see you on those future webinars. After this presentation, we'll send everyone an email with a link where you can sign up for those webinars, as well as a copy of the PowerPoint presentation you see on your screen. And we will also share in that email a link to our YouTube channel. And we try to put on our YouTube channel very high quality information about, again, the full spectrum of U.S. immigration topics, both full webinars, including this one, as well as shorter videos that cover those topics. So please do check that out. As I mentioned, this webinar will be posted to our YouTube channel. It is being recorded. If you have a question during the presentation, there are a couple things you can do. You can send in the question through the chat box of Zoom, or you can send it in through the Q&A function of Zoom. I'll be actively monitoring those questions, and we'll either share the questions with Ian or we'll answer them myself as they come in if they're relevant to what we're talking about, or we'll save them for the end. But either way, we do expect to get through all the questions that come in, so don't hesitate to send those our way. Without further delay, I will go ahead and pass off the presentation to Ian to talk about how our green card system works in the US.
Great. Thank you very much, Dustin. And it is great to be here. So I think that one of the things that has to be kind of clarified before we jump into the moving to a green card is just how the system works. And one of the reasons it has to be clarified is because the system in the United States is very different from other countries. And many other countries have what's called a points-based system where people get points for a number of different things. They might get points for speaking the language, for how long they've been in the country, for education, age, all of these things they might get points for, and then as you add up the points and you get to a certain number, then you may be eligible for permanent residency, because that's what a green card is. It's permanent residency status. Now, the system in the United States, though, works very differently because there aren't any visa categories that lead to a green card. And no matter how long you're in the United States, that doesn't kind of assist you with respect to getting a family-based or an employment-based green card. So you could be here 15 years, you could have gone to school here, you could speak the language, you could have relatives here, and it doesn't assist you, certain relatives here, and it doesn't assist you with getting a green card in the United States. However, the way it works here is that there are a list of green card categories, and we're going to talk primarily about the family-based categories and employment-based categories, but there are others. There are a list of categories with criteria, and if you're eligible for a green card, you can apply, right? And the criteria don't ever say there aren't criteria, for example, that say, well, one criteria is being in the US for 10 years, right? All of the criteria are criteria with respect to something that you have to have done in the past, or some familial relationship, but they are very specific criteria, and we're going to be getting into those during the presentation. Now, as I said, we're going to primarily talk about family-based and employment-based green cards. The family-based green cards are broken up into two different categories of immediate relative category, and that is not what you would think of as an immediate relative. It's defined by law. An immediate relative would be, for example, if you were marrying a U.S. Someone that didn't have wasn't a U.S. citizen, was marrying a U.S. citizen, and also a U.S. citizen over 21 that wants to sponsor their parents. That's immediate relative category. And the reason that becomes important is because the immediate relative categories are, for now, we'll just say they're always current, so you can get the green card a lot faster. And then we move into the preference-based category. So, most of us would think of sibling as an immediate relative, but an example of the preference-based category is a U.S. citizen sibling that wants to sponsor their sibling. And the problem with some of the preference-based categories, in fact, most of them, is that there are very long waits to get the green card. So the category that I just mentioned, there's a 15-year wait or maybe even longer wait to get the green card as a U.S. citizen sibling that wants to sponsor his or her brother. Then the brother or sister. And then the employment-based green cards are broken into 5 different categories. We're going to talk about all of them today except for EB4, which is a religious-based category. The firm doesn't do any of those. And but we are going to touch on each of the employment-based categories. And you will see again where, with the employment-based categories, they're just, a list of criteria. And if you're eligible, then you can apply for them. And if you're not, then, then you either have to, probably stay in the non-immigrant visa category that you're that you're in. So we talked about the family-based green card a little bit already. I talked about, what constitutes an immediate relative. A lot of people a lot of our clients in the U.S. that have non-immigrant visas, meet a significant other, and that significant other happens to be and I'm going to use this to describe both the preference-based categories and the immediate relative category, but sometimes that significant other is a U.S. citizen. And other times it's a green card holder. Now, if the significant other is if someone's on a visa like an L or E2 or TN or some other non-immigrant visa category, and they meet a U.S. citizen, then the U.S. citizen can sponsor them for a green card. And as I said, there's no wait for that. No wait in terms of, you obviously have to wait till the petition is processed. However, the green card category is always available. There's not a backlog in that particular category. But if it was a green card holder that was sponsoring the person on a non-immigrant visa, they can still do that, but that is within a preference-based category. And when you're in a preference-based category, you have to look at what's something called the visa bulletin and see whether or not the green card is current at that particular point in time. And right now, what's interesting is the example that I just used, an individual who has a green card that wants to sponsor someone. That category right now is not current. It was last year for for most of the year, but right now that's not current. And with the preference-based categories, there are a number of them. Like for example, parents sponsoring unmarried child or daughter over son or daughter over 21, and different but they're just different categories, and each of them will have different timings associated with them. Now, what I'm going to describe now really applies to all of the green card categories, but I'm going to describe it because the family-based one comes first. So when you're looking at getting a green card, you're going to have either a 2-step process or a 3-step process. So and we're going to use the family-based to describe both. So let's just use the simple example of a U.S. citizen is sponsoring someone on a visa. Let's say the person's on an E2 visa for a green card. Now, the first part of that petition, so this is step 1, it's always going to be the same, whether it's employment-based, family-based, in terms of you have to prove that you're eligible for the particular criteria. So in this case, it's going to be an I-130 that's going to be filed, and you have to show that you are, that's a bona fide relationship, and that you're marrying for, to start a life together, and that's what the I-130 has to prove, right? So that's kind of step 1. When we talk about employment based, then it's going to be similar in the sense of there's always going to be a step 1 with respect to proving what the statute says the requirements are for that particular visa or green card. So now the step 2 is always going to be dependent on whether the person is in the United States or outside of the United States. If the person is outside of the United States, the person is going to go to step 2 by doing something called consular processing, which means they're going to be getting the green card at a consulate. They'll be getting a visa at the consulate and using that visa to enter the United States to get the green card. If you're in the United States, you do have the option still of consular processing, but a lot of people will do something called adjusting status in the United States. And when you're adjusting status in the United States, you're filing a form called an I-485. And the good thing about that particular form is that as long as your category is current, so the example that we're sticking with right now is the example of a US citizen sponsoring someone, that category is always current, you're able to file the I-485. And the good thing about filing I-485 is that you're able to file the employment authorization and travel authorization with that. So the person can get underlying employment authorization to work anywhere and also get authorization to travel, because once that form is filed, you need that authorization to be able to leave and re-enter the United States. Now, the thing I wanted to go through as well, and this doesn't apply to all green cards, because, I said 1, 2, or 3 steps, that there could be a third step. Now, in this example that we're using of a individual who has a U.S. citizen that sponsors someone for a green card, in that instance, after 2 years of having the green card, the applicant has to file what's called an I-751 and show that they're still a bona fide marriage, they're still together, et cetera. Because what happens is they get a conditional green card for 2 years, and then they have to, after the 2 years, they have to, prove to the government yet again that it's a bona fide relationship and that the relationship lasted. And there are some other petitions. We'll see EB5 does the same thing, where it's a 3-step process instead of a 2-step process. The majority of the processes are 2-step processes, but there are some that are 3-step. But again, as we're going through all of the green card categories, like, think of that in the sense of it's always going to work in that way. It's going to be step 1, which is going to be a particular form. In this case, if it's a family-based form, it's I-130. Step 2, it's either going to be consular processing or I-485. And then if the particular green card has a step 3, then it's going to be usually a removal of the conditions, because it means that the person's got to obtain a green card, but there are some conditions surrounding that green card, and the government wants you to file something after a 2-year period to remove those conditions. Perfect. So now we're moving into the employment-based green cards. And as I mentioned, employment-based green cards move from EB1 through to EB5. Now, the first one we're going to talk about is moving to a green card based on extraordinary ability. And one of the things to note is that most of the green card categories, or some of the green card categories rather, have a very similar non-immigrant visa associated with them. So that non-immigrant visa, again, it doesn't mean that it leads to a green card or helps you get the green card, but some of the criteria could be similar and are in some cases very similar. So the EB1A, we might have, we might have a client in the United States on an O1 visa, and the client that's in the United States on an O1 decides that they want to get a green card. And an O1 visa is similar to an extraordinary ability EB1A because it lists a bunch of criteria and you have to meet 3 of them, at least. And then you look overall to see if overall the government feels that you've risen to a particular level such that you're at the top of your field, right? Now, whenever you have a situation where there's a similar category where, where in this case, for example, you have an O1, getting the green card, even though the criteria might look similar on paper, getting the green card is always going to be much more difficult. So think of when there are these similar categories, think of it as an O1 squared or something like that, or even more than that. So, but you see the criteria listed here, and the other thing I want to point out is that during this webinar, I just touch on these green cards. We do have, as Dustin mentioned, we are up to probably a couple of webinars a week, and we do have separate webinars on each of these topics, because each of these topics we could talk for an hour about them, the extraordinary ability petitions, and go through each of these criteria and explain what they mean and give examples of them, et cetera. And we do that, but we do that in the petitions where we focus, the webinars where we focus very specifically on the particular type of petition. But just to give you an example of one here. If someone commands a really high salary, if they commanded a really high salary in the past, the government sees that as a basis for making an assessment that maybe they're really good at what they do, right? So that might be one of the different criteria. If someone has been judging the work of others, so they're deciding whose article gets published in a journal, or even if it's a traditional, like more like an American Idol type judging, like the people who are judges on shows like that usually are quite accomplished, right? So that could be another thing that someone could point to say that they've risen to the top of their field. The one other good thing about this particular petition is you can self-petition, so you don't need an employer to do it. And we have successfully filed petitions for entrepreneurs in this category as well. This process is a two-step process. So the first part of the process is an I-140. So the I-140 goes back to proving that you have met 3 of the 8 criteria that are listed above, and then we go right into if that's approved, or if the category is current, and you file an I-485 petition, for example, if you are in the United States, then you are going to be able to do that, and that's the second part of the process. And again, when you are looking at this and you are deciding, let's say that you're in the United States and you say, oh, I filed the I-140, and you can premium process an I-140, so for this particular petition, and get it approved in a couple of weeks. But let's say you also want to file the I-485 concurrently. You first have to look at the visa bulletin to see if the category, the particular category EB1 is actually current, right? And so, when you look at the visa bulletin, it's broken down by country. So right now, under EB1, I think there's only 1 or 2 countries that aren't current right now. I believe India is not current, and that might be the only one under EB1 that isn't current. EB1 also has EB1B and EB1C. EB1C, I'll just touch on it briefly. EB1C is very similar to, as I said earlier, there are a lot of non-immigrant petitions that are kind of similar. EB1C is very similar to the L1A. L1A is another non-immigrant visa, but the EB1C again would be L1A squared, right? You have to be an executive or a manager. If L1 needs 5 employees and EB1C might need 50, so everything is going to be more, even though when you look at the requirements on paper, they do look very similar. And the one interesting thing is the visa bulletin is not broken down by EB1 ABC, it's just EB1. So regardless of how you're coming in under the EB1 category, you're going to be subject to the availability of the green cards or visas based on the EB1 criteria. So okay, so national interest waivers. So this is a category where we tend to move a lot of people from non-immigrant visas to green cards. So it can be someone that's on an H-1B, it can be someone that is on a TN, it can be someone on an E-2. And the reason is because this particular category lends itself to creativity, I think, much more than some of the other ones. The other categories are defined, like the other visa types, like for example, the EB1A is defined by criteria set out in a statute. The EB2 national interest waiver is defined by a case, right? So an interpretation, how a particular case was interpreted, because the statute doesn't really describe very well exactly what the government was getting at. So the case that deals with national interest waiver, it's a case called Danisar. And Danisar was interesting because it was decided at the end of 2016, so really started taking effect in 2017, which isn't that long ago. And the case that governed this area before made it very, very difficult to get a national interest waiver. So there were very few processed, right? So you had to, kind of be someone who invented a vaccine or something like that to get a green card under national interest waiver in the past, where now you can be very creative and look at the criteria. The first of which is that what the person's coming to the United States to do is considered to have substantial merit and national importance. So the first thing we're always doing in a national interest waiver case is saying, what are you coming to the U.S. to do, and defining that very clearly. And if what you're coming to the U.S. to do is of national importance, and then you could be considered for a national interest waiver. And the second, so when we look at things that government feels nationally important, like it could be jobs, it could be the economic impact of what you're coming to do. It could be what you have invented. It could be what your company does. Like if your company is focused on cybersecurity, or if your company is focused on artificial intelligence, or even if it's something your company is selling that the government feels that is nationally important. All of those things could be used to describe that you may qualify for a national interest waiver. So the first part of the first of the three criteria, that can really usually be defined in a way that you'd meet that particular criteria. However, national interest waivers get tricky when you move to the second, because we turn away from generically what is going to be done to the actual individual. And the criteria here is that the person is well positioned to advance the proposed endeavor. I used entrepreneur in the slide, but it's just the individual is well positioned to advance the endeavor. In this particular slide is using the entrepreneur as an example. So this is where it seems like a pretty straightforward criteria, but it does get much more difficult to prove, because the government is really looking at your track record and what you've done in the past. And if you're getting a national interest waiver as an entrepreneur, they want to see that your company is already well financed, that maybe you have investment in the company already. They want to see that you have contracts already, or they want to see that if you say that you're going to create jobs, they want to see that you've done that already. That maybe in your home country you have started a business and created jobs, and so that's a real focus. So it is a lot more difficult. And the third criteria is much more general. I think, I don't think I've ever seen a national interest waiver case that has met criteria 1 and 2 and failed on 3, because the fact is we use a lot of what is in 1 and 2 to support 3, which is that the government has a process already where they've said something is nationally important, that's protecting U.S. jobs. So we're trying to show the government that, well, why on balance should we, give this person a green card? And usually we're pointing to the same things. You should give it to them because what they're coming to do is nationally important. And then within prong 2, we see a lot of very positive things about the individual, right? That we point out, right? They may have a patent. They may have done this before. They may have gone to a great school. They may have a really impressive background, like things like that we can point to. And then the other kind of really important thing with national interest waiver, and this unfortunately gets confused quite a bit, is that national interest waiver falls under the EB2 category, which is, we're going to talk about something right after this, which is being sponsored for a green card, which also falls under the EB2 category. So the EB2 category, before you can even move to the difficult part of analyzing the DANISAR prongs, you have to have one of these 3 things: either an advanced degree, so it's a master's degree or higher, or a bachelor's degree plus 5 years of progressive work experience, or something called exceptional ability. So that's not the same as extraordinary ability, it's exceptional ability, which are criteria that are listed that you again have to meet kind of 3 of. So if someone had a high school degree, for example, they still might be eligible for national interest waiver if they could qualify here under exceptional ability. But this is just a threshold issue, right? Like it's almost like if you have a master's degree, then you move to the next part. If you have a bachelor's plus 5 years, you move to the next part. But we do get a lot of calls from people who kind of look at the exceptional ability criteria within EB2 and they say, hey, I meet 3 of those and aren't I eligible for the national interest waiver? And it's like, well, no, not at all, because all it means is that now you can start to look at the hard part of national interest waiver. And when we look at national interest waiver, we are, think back to the last slide when we were looking at EB1. It's the exact same petition process where you're filing an I-140, and your I-140 in this case is proving the 3 Danisar prongs plus proving the threshold considerations, and then the then you file, if you're in the United States, you can file an I-485 if it's current. And unfortunately, it's not current for any country right now. But you can file it if it's current. And then if not, you have to wait for it to be current. And if you're outside of the United States, then you can, you can file using consular processing. And this is just, this particular green card is a 2-step process rather than the 3-step process. So I touched on this. The next 2 that we're going to talk about, and this is a way that a number of people get a green card. Someone could be in the U.S. on an E2, and while the E2, because the E2 means that you have some ownership in the company, you can't sponsor yourself or your spouse. But sometimes the spouse will get a job, and then they can be sponsored, and that can be that can lead to a green card. But EB2 and EB3. It's a company sponsoring you for a green card. It could be sponsoring under professional, it could be sponsoring under skilled worker, and it can even be unskilled worker. Like there's not really any job that you can't sponsor. But the issue is that what you do have to do is prove that it's through a process called PERM. You do have to prove that you can't find a qualified U.S. worker. So if you are trying to sponsor someone for unskilled labor, like I've seen even PERMs go through for nannies, for example. And if you're trying to hire someone through for unskilled labor, or people that don't have degrees and things like that, it might be tough to weed like when you're developing the job description and posting it, because you actually have to do that. If you can't put in the job description in terms of the requirements that this person needs a degree in early childhood education or something like that. If you can't do that, then it's going to be difficult, because you might get a lot of applications, right? So we put a job posting up for a paralegal recently and got 141 applications, probably 70 of which don't have anything to do with the being a paralegal. However, if there are no requirements, then anyone who applies can be eligible for the job according to the Department of Labor standards with respect to doing this, unfortunately. So, and then again, this is going to be the same process where you're filing an I-140 and I-485, and if you're in the United States, and you wouldn't have to later file something to remove any conditions or anything like that. But again, can't stress enough checking to see whether the category is current, because there are weights that you do have to kind of manage when you're doing this.
Great. And Ian, that is a great segue to a question that came in. What does it mean when you say that a visa category is current?
Sure. So there is a bulletin. So actually, let me back up to describe why this happens. So when the law authorizes a certain number of visas, when I say visas and green cards are synonymous in the immigration world, but the law issues a certain number of green cards to be issued by category and by country every year, except for the immediate relative category that I talked about before. So let's just take an example. Let's take an example of green cards within the sibling category, because that's a really, really delayed category. U.S. citizen wants to sponsor their sibling. Now, what happens is that every year, I'm just going to use a number because I don't know the exact number, but every year the U.S. government can issue 20,000 green cards based on that particular category, people who want to sponsor their siblings. Now, that number is broken down now by country. Right. So it's 20,000, and there's calculation of formulas based on populations and things like that. It says, okay, this amount can go to China, this amount can go to India, et cetera. So once the country uses up that quota in the year, then people who are still applying for it from that country start to go on a wait list. Right. So Now, for the sibling category that I talked about, every country has used up their amount, and they've used it up so much that no matter which country you're from, if you wanted to sponsor someone for a green card, there would be a 15-year wait before and that's just an estimate, but a 15-year wait before there were green cards available. So when you go to the visa bulletin, you can see, okay, well, right now they're working on applicants that submitted their green card application for their sibling in 2007, right? So you know that there's a really, really long wait. So when there is a wait, that means the visa category is not current. Right. So even if you got one of the step ones approved, the I-140, the I-130, et cetera, there's nothing you can do about it until the category actually is current. So that's what that means.
Perfect. Thank you. And we'll talk about that more actually in this next slide about the EB5 green card. Now, the EB5 is a really interesting category of the employment-based green card, and it's one that we see being somewhat commonly used by our E2 clients, because what the EB5 allows is essentially a green card through investment. Now, the investment is significant. It can be either $800,000 or $1,050,000. The difference there is whether the investment is made into a business that is in a targeted employment area, which is defined as a rural area or an area of high unemployment, or an infrastructure project, which is a new category that was created. If you're investing in a business that's one of those, high unemployment, rural, or infrastructure, you can qualify for that lower investment amount and invest $800,000, and you've satisfied that requirement. If you're not investing in one of those businesses, so let's say that you are starting a restaurant in an affluent area of Los Angeles, you may need to invest that $1,050,000 amount. Now, it is more complicated than just looking at where the business is. You may be able to use areas that are next to your region to argue that you qualify for the targeted employment area discount. And that's something we help our clients with. But I think the big takeaway is that there is a reduced investment amount if your business qualifies for that targeted employment area or infrastructure project. Now, the other big kind of umbrella topic to discuss with the EB5 is there are two big pathways to an EB5. The first is what is called direct investment, and the second is called a regional center program. Most EB5 green cards are applied for through the regional center programs. Now, what that is essentially when there's a very large project. It could be a shopping center, it could be a resort, a hotel, it can be a subway station, for example, a metro station, that costs tens of millions, if not hundreds of millions of dollars. You could have dozens of EB5 applicants that are supported by that one regional center. The regional center needs to apply for approval through U.S. Citizenship and Immigration Services. And once approved, it can basically support any number of EB5 applicants. That can be an extremely convenient pathway to an EB5. And the reason is that regional center projects tend to be in places that qualify for the lower investment amount. So you can usually qualify through that $800,000 investment amount. The other reason why they are very convenient is that they tend to be fairly passive. So the applicant usually doesn't have any kind of a direct role in, say, that resort being built or the hotel being built. They really are more or less a passive investor. So if you have the funds available and you say you are a professional already, you don't have a business that you want to invest directly in, the regional center can be a very good option for the EB5 green card. However, if you are, say, an E2 visa holder, or otherwise you have a business that you want to be directly involved in the United States, then the direct investment option can be a good one. And that really is more of a traditional, it looks like more of a traditional business. It's, say, you've invested $800,000 into, say, a restaurant in a targeted employment area. You will be employing at least 10 people. We'll talk about that in a moment. And you're going to be actively involved in the management of the business, then you may be able to qualify for the EB5 through that a direct investment pathway. But keep in mind, there are those two main pathways, one much more passive, one much more active, depending on really what your priorities and preferences are. Now, if you look at the EB5 regulations, one of the term you hear tossed around a bit is you must invest in what's called a new commercial enterprise. That terminology can be very confusing. What it means, a new commercial enterprise is any for-profit entity that was created after 1990. So it does not have to be something you've created new, but you do need to invest in a business in the US that is for profit, that has existed, that was created after 1990. And basically, the funds you use to invest in that business need to be your personal funds. And this gets us to what really does tend to be the biggest, most significant hurdle to the EB5. And that is proving where the money came from that you're investing into the new commercial enterprise. USCIS, as Ian mentioned before, they impose an extremely high standard on this. Essentially, they do a thorough accounting of exactly where you got the money from that you're investing into the business. Again, that's either $800,000 or $1,050,000. You have to document from the source of the funds all the way, every transfer of those funds, all the way to the new commercial enterprise. So if you sold property, say in China, you sold an apartment in China, you have to prove that you owned the apartment, that you sold the apartment. You have to provide the contract for the sale, the movement of funds from the seller to you, from the buyer to you as the seller, then into the United States, and then from your personal account into the United States, into the business account. So it really is a thorough accounting. This really is an area where it is important to work with an attorney to guide you on exactly what documentation you need to have. But do anticipate that that is a very high bar to meet. You need very thorough documentation. Now, as Ian mentioned, the investment can be made over time. What is really critical, though, a few things. First of all, they do need to be your personal funds. So let's say that the funds are from someone who is gifting the funds to you, say a parent. Your parent is gifting you $800,000 so that you can apply for an EB5, but your parent wants to transfer the funds directly from their personal account into your new commercial enterprise. That is going to create problems because you need to first show that they are your funds. So they need to transfer the funds first to you, to your personal account, and then you can transfer those funds to the new commercial enterprise account. But it is critical that the funds be your personal funds. Also, they cannot be retained earnings. So if we're talking about the E2 context, let's say you have a very successful E2 business. It generates $1 million in retained earnings a year, and you decide to take 800,000 of those retained earnings and invest them directly into the company as an EB5 investment, that also won't work. You need to actually distribute those retained earnings to yourself so that they are your personal earnings. You need to pay taxes on those, have documentation proving that they were an actual distribution. And then once they are clearly your personal funds through that documentation, that distribution, then you can invest them even back into that E2 business if that's what you're using as your EB5. But they do need to be your personal funds. The other very important aspect of the investment is this employment requirement. So the EB5 is called, it's not actually typically called an investor green card, it's called an employment-based green card, so a job creation green card. And that is a key piece of the EB5. You have to prove that you are creating jobs from your investment. So that $800,000 or that $1,050,000, you have to show that those funds were used for the purpose of creating jobs. Um, that's really key. The jobs cannot have been created before you invest the funds into the business. So in an E2 context, again, let's say that you've started the business 5 years ago. You currently have 10 workers. You have those earnings that you've paid taxes on. You invest those back in, and you say, "Hey, I have 10 employees, and I've invested $1,050,000 into the business." That's not going to fly. The reason is you have to show you employed the people after you made that investment of 800,000 or $1,050,000. So when do you actually have to employ these people? Fortunately, you don't have to employ them at the initial stage of the application. You do have some time to employ them. We'll talk about the process of applying for an EB5. But the takeaway is you can apply for an EB5 based on a very detailed and thorough business plan and show how you will employ those 10 workers over time. It does generally have to be before you apply to remove the conditions on the green card, but that will be several years down the road. So let's talk about that process. Step one is filing the I-526, and that is filed with USCIS. That is what Ian was talking about before. The parallel in family-based immigration green cards is the I-130. So if you're applying based on a family relationship, you'd file the I-130. If you're applying based on an EB1, EB2, or EB3, which Ian talked about before, you'd file the I-140. In the EB5, you file the I-526. And the I-526 is basically showing the government how you qualify for the EB5 green card. Once that is approved, you can file the I-485. Now, the recent law, which was passed in 2022, allows you to file the I-485 at the same time that you filed the I-526, which can be an enormous benefit to applicants, because what the I-485 is, and again, Ian discussed this before, that is the green card application. So the I-526 is proving that you meet the kind of the baseline qualifications for the green card. The I-485 is basically the green card application. And once that's approved, you get your green card. Now, Ian talked about the visa bulletin. So that's where the I-485 concurrent filing at the same time as the I-526 is really key. If you, if you're at your computer right now, it could be helpful to go ahead and Google January 2024 visa bulletin, and then scroll down to the employment-based categories. And if you look at the chart, you'll see a chart on your screen, and you'll see there are several rows that say fifth, and then one says fifth unreserved, one says fifth set aside for rural, fifth set aside for high unemployment, and fifth set aside for infrastructure. So if you look at that chart, you see that the row saying fifth unreserved, you'll see C for all areas except those listed, and then you'll see C for Mexico and C for Philippines. What that means is that those categories are current. There are green cards immediately available for those categories, which means that you can file, and if you're in the US, you can file an I-485 and an I-526 at the same time if you are from Mexico, the Philippines, or any other country except China or India. Because if you look at China or India, you see dates that go back to 2015 and 2020. So what that means is if you are applying for an EB5 green card and you don't have that reduced investment amount, meaning you're not applying in a high unemployment area, you're not applying in a rural area, and you're not applying for an infrastructure project, and you're from India or China, you are going to be waiting years before the green card becomes available. But if you are from India and China, if you are in the US and you are applying based on a high unemployment area, a rural area, or an infrastructure project, you can immediately file your I-485 with the I-526. And that's because the categories are current. For those categories, excuse me, even for Indian citizens, or those born in India or those born in China. So for those born in India or China, it is a huge benefit to apply through a TEA, Targeted Employment Area. You can immediately file your I-485 with the I-526, which means you can immediately apply for work authorization, travel authorization. And once those are approved, you have a lot of flexibility in the process. So do keep that in mind. I know that was a very long explanation, but it really is key because your experience with the EB5 can be very different depending on which category of business you're applying in. So that's really critical to keep in mind. And that's especially important for those from China or India. Now, the final step in the process of applying for the green card through the EB5 is filing the I-829, and that is the application to remove the conditions. So for an EB5, when you file the I-485, you're applying for a conditional green card. And what the government is saying is we will, if we think you've met the requirements up to that stage of the process, we'll give you a conditional green card, but down the road, a couple of years down the road, the conditional green card is valid for 2 years. In 2 years, you have to apply to remove those conditions, which shows in that I-829, you need to prove that you're employing the required number of employees and that your investment has gone toward the employment of those employees. Excuse me. So once your I-829 is approved, you are issued an unrestricted green card. And that is really a moment for celebration because, as you can tell, it is a long process to get in EB5. Our firm does, with some regularity, file lawsuits against the government because the government is taking a long time on these applications. Generally speaking, when someone has been waiting 3 years, 2 to 3 years for their I-526 to be adjudicated by USCIS, and we haven't heard anything, we would have the discussion with the client about whether they want to sue. We have had a good track record on those lawsuits, but the takeaway from this is not a fast option. So it really does make a big difference to be able to file that I-485, get your work authorization, get your travel authorization so that while you're waiting for that EB5 to be approved, you can work and travel. So with that, I will go ahead and pass it back to Ian to talk about some other green card options.
Perfect. So yeah, so the employment based and the family based are the key green card options, but there are some others. Like, so for example, the diversity lottery, which is around 50 something thousand green cards they give every year, and to there's some very basic qualification requirements, and they sometimes by when they feel they have enough immigration from particular countries, then those people from those countries can't apply anymore. UK just came back on the list. They were off for a while, but I think the last one they came back on the list, and that usually starts up in October, and then they do the lottery in May. So that's something that if you are on a non-immigrant visa, we often have at least one of our clients that wins the lottery and gets the green card. There are other humanitarian-based green cards, such as if you witness a crime, or if you're a victim of, and you help the police, or you're a victim of domestic abuse and things like that. There are other green cards that might be available to you, and sometimes other situations if you're in the United States for a long time and you're going through removal proceedings, and if you've been here for over 10 years, then you can maybe do something called cancellation of removal. And then there's others with like asylum, for example. But we, our firm doesn't do a lot of those, but just, there are, just to let you know that there are other options out there. And we always hope that immigration reform will yield something someday, but I think that that's not, not in our immediate horizon. And I think that one of the key things with when you are on a non-immigrant visa, because of the way that the system works, is to really, and because given some green cards take a long time, as Dustin was just going over how long it takes to get an EB5, you could be in the system for over 10 years and still not have an unconditional green card. Because of the timing associated with the different pieces. So you do have to make sure that you're maintaining your underlying status, or have some underlying status if you are in fact still in the United States. And that just requires, significant planning and making sure that, because once you file an I-485, for example, you do have to wait till you have travel authorization to be able to leave the United States. And then you always have to kind of be looking at your visa expiration dates. And if you don't have a dual intent visa, like an L1 or H1B or O, then you might run into difficulty with renewing your visa while you're going through a green card process. So it is, I think that there's a lot going on. And sometimes people have people that do have parallel green card strategies. Like you can apply for, if you're eligible for, we had one person that was applying for EB5, and then she ended up marrying a U.S. citizen. We have a person that was going through the EB5 route, but then she also realized she was eligible for national interest waiver, which is a better choice because it's faster and cheaper and definitely less complex. So sometimes people do, and I think that sometimes people do have parallel strategies, and I think that the key with all of this is really planning.
Perfect. Thank you, Ian. So we've gotten some great questions over the course of our presentation. The first question is, I am 59 years old and I'm just launching an enterprise. Is age likely to be a limiting factor if I apply for either the E2 or the EB2 NIW? And Ian, if you don't mind, I'll also add, we've had clients who are ready to retire and are considering an employment-based visa. So what requirement is there that I'll add as a kind of tangent?
Sure.
What requirement is there that the person actually stick with the business for some time after they apply for the green card?
Yeah, exactly. I think that I think 59, I think there's no impact for either the E2 or the EB2 national interest waiver. I don't think it's going to make any difference. Certainly not for the EB2 national interest waiver, and for the E2, I don't think it would make any difference. I think it's an interesting question, Dustin's extension. If someone was, wanted to retire, it could impact not so much because the government is kind of less likely to approve a petition for someone that's older, and this applies more to E2. I think that the age is not going to impact the EB2 national interest waiver much at all. I think that's going to be, it's because the one of the problems or one of the differences between EB2 NIW and E2 is that E2s are processed at consulates, and consulates don't really have to give a reason for their denial. They can just deny and then say go away, and you don't really know sometimes even why they deny. They can just get something in their head and deny. For EB2 national interest waiver, that's all done through paper. No one meets you really in a meaningful way. If you're in the United States, they waive almost 99% of employment-based visas. And even if you were approved and you went to a consulate to get the visa to come to the green card for doing consular processing, I can't imagine that would come up, because they can't write that as a reason, right, in their explanation. But I think if someone was planning on retiring, or the government, like let's say that someone was a lot older, and the government questioned whether they're going to be able to run a business, and I think it would have to be quite a bit older than quite a bit older, then perhaps it could impact the E2 when you go, but we had one situation where someone came to us that he got bad legal advice, and he was doing an E2. And the question was, his 80-year-old mother, can she, be the E2 employee or the other E2 investor and get an E2? And I do think that would have been difficult to get the E2 visa for his 80-year-old mother. But then I explained to him that there's another option that no other lawyer mentioned to him, that he could get his mother on a B1, B2 to join him and accompany him the whole time that he's there. And he's like, wow, no one ever told me this before. But I think, that's quite a stark contrast, right? Like someone who's 80 something, like some people do work well into their 80s, like Judge Judy and things like that, people do, but it's maybe not as common, I'd say. So that's why it might come under a bit more scrutiny. So
Perfect. Another question regarding the 5-year bachelor's degree plus 5 years of progressive experience that you mentioned before. How does that work? And we're talking for the EB2 NIW. How does that work for a business owner? So is it if you're pointing to 5 years of experience, would owning your own business for 5 years satisfy that,
Yeah,
or
it would. Yep,
okay.
it definitely would. Yeah, it definitely would. So and the experience doesn't have to be relevant to what you're doing. Like so let's say everything kind of has to link in some way, but it doesn't have to be a direct link. It doesn't have to be as strong as, like, for example, a degree matching for H-1B or degree matching for a PERM or something like that. Like, let's say someone studied marketing in school, has a bachelor's, and they studied marketing, and then they ran their own firm for 5 years. That would absolutely qualify because they have the bachelor's degree in marketing. You could say that there's some marketing aspect related to the business. If someone had a science degree, like, pre-med degree or something, and they were then saying, okay, well, I have bachelor's plus 5 years experience in running my own business, that may not qualify. I think you'd have to kind of really dig deep to see how the bachelor was related, because they all kind of work together. But it can be loosely, the experience can be loosely related, to come to that point. And then if you don't qualify there, you might be able to qualify under exceptional ability, because one of the criteria of exceptional ability is you have a degree, and that can be any degree, right? So it doesn't have to be a degree in the field. So
Perfect. Going to perm, the perm process. I think there's some hesitation that if a qualified U.S. worker ends up applying for the job, you have to shut down the process and you can't take on the foreign applicant. Um, could you say more? The question is there some degree of reassurance or certainty that with the right guidance from an attorney, one should generally be able to successfully obtain a PERM certification if there's a willingness from the employer to sponsor the employee? I know it's a hard question, but maybe add some
yeah.
detail to, you're going to get, say, our paralegal applicants, you're going to get many. How does it ever work then that say someone applying for that job might get through the PERM process?
Yeah, well, I definitely understand the question and the difficulties associated with perms. Some perms do get denied, right? So that should, answers the question that some perms don't actually get through. And often when they don't get through, it's because of, often if they're denied, it's because the Department of Labor looks at it and they believe that the recruitment wasn't genuine, or there wasn't a bona fide job, or the job description was too vague, or whatever reason. But the fact is that if you have a reputable lawyer that is, assisting an employer with the process, the lawyers, we would never advise to a client that actually did interview someone that met the requirements, that they should continue with the perm. We've said that to clients before, that they should, like, we will do everything in our power to try and disqualify the person, right? Like, or the companies will do everything in their power to try and disqualify the person. But there have been instances where like, you've advertised for a lawyer, U.S. qualified lawyer with 5 years of degrees, 5 years of experience litigating complex corporate transactions, and you get an applicant that has exactly that from a large law firm and has 7 years of doing that, and is willing to take the wage, like, applied for the job and is willing to take the wage. Short of fraud, you can't disqualify that person, right? So, employers generally don't want to do that, and certainly reputable law firms wouldn't encourage a lawyer to do that. But that being said, many people get sponsored through the green card process, the sponsorship process, because we do tailor. You can't tailor a job to someone's exact experience. But there is a lot that goes into crafting a job description, right? So it's and we do. That's why I said earlier, when the less requirements there are, the more difficult it is because more people can apply, right? If you're basically just saying that a bachelor's degree in any field, or no bachelor's degree, let's say you wipe out, like, the person doesn't need a bachelor's degree, and you're just saying, 2 years of experience in, I don't know, childcare or something, taking care of children. Let's say if someone's a nanny or something, right? And you're going to get a lot of people that apply and probably meet the requirement, right? Because you can't pad the requirements either. They have to be what are called minimum requirements. Sometimes when the Department of Labor audits a perm, that's what they go on about. They like, and for example, you can't. One of the things, one of the audit triggers in a perm is including a foreign language requirement. Because as many know, that if you include a foreign language requirement, you exclude, I believe, over 90% of the US population. So it's a very large number of people who don't speak another language. And so the Department of Labor knows that, and they feel that, and rightfully so, I think, is that there are not that many jobs that occur. It might be better to have someone that speaks Spanish or speaks, different languages. But when you're talking about minimum requirements for a job, they say, like, they audits will come back and say, when people have a foreign language requirement, well, they'll say, well, what about your clients? Like, don't the clients that you deal with, don't they speak English, right? And it's hard to sometimes prove that, especially with English being um, such a prevalent language, the default language in many countries, that it's often very difficult to answer. There are some other audit triggers as well, but that's a big one.
Perfect. And a few additional questions have come in. I think some of them we can answer quickly. Our firm does handle marriage-based green card applications. Um, this is an interesting question, and I know we're running up on the limit of our time, so we'll probably get through these very quickly. Feel free to follow up with us, by the way, if you'd like to schedule a consultation. And this webinar is being recorded. We will post it to our YouTube channel and send you the link afterward. I have an employer-based H-1B visa as a medical researcher. If I start an application for EB2 NIW, can I switch my career to, say, finance in the following year?
Yeah, I don't think to finance, no. I think that there is an ability to kind of move with an approved NIW petition, but that's the whole kind of issue with it, is that you have a petition based on saying that you are doing something, right? And that's in the national interest. And then if by the time you get to your I-485 stage, you're not doing that or don't plan on doing that, that can be a problem. So it is a bit of a complicated area, yeah.
Great. I'm currently on a TN going through the green card process. They're at the DOL step. This is a quite nuanced question. From now until the end, can I receive promotions and salary raises? I don't know if.
I don't know.
Yeah, we'd have to schedule a consultation for that one.
Well, to be quite honest with you, I'd say go back to your company, because it really depends. Honestly, it's not even something we can answer in a consultation, because what I can answer is that there are requirements with respect to increasing salary when someone is going through a PERM process. But in order for us to know what those requirements are, we'd have to see the PERM, we'd have to see the department, like the code that it was done under. We'd have to go back to the FLC website to see what the range was. We'd have to see the prevailing wage and things like that. So if your employer's telling you that they can't increase your salary because it's a PERM issue, that could very well be the case. That is very, very possible. But it's just, in order to see exactly what could happen, we need a lot more information. Yeah.
Great. And this last question, I think, sums up the presentation quite well.
Yeah, exactly. So
I want to move from an E2 to go ahead,
yeah.
Ian. Sorry.
Yeah, no, they may have come. I read that one. They may have come in late. So if this would be a good, like, it's perfect segue to this will be on YouTube, and we'll be sending you a link so you can kind of just watch everything that we talked about during the
That's right. We talked about a number of good options to move from E2 to a green card. So do check out the recording. Please reach out for a consultation if we can be helpful along the way. And keep an eye out for that email with the presentation, a link to our YouTube channel, and future webinars. So Ian, thank you so much for taking the time. And thank you all for the excellent questions and for spending this time with us. We hope to see you on future webinars as well.
Great. Thank you very much. Thanks. Thanks everyone. Bye-bye.